Sharda, we can start with the session.
Uh, o- okay. Very good afternoon to Honorable Speaker, Ms. Kavita Nigam, respected management members of Seva Mandal Education Society, Principal Professor Mala Pandura, distinguished delegates from India and abroad, special invitees, teachers, and my dear students. I, Ms. Sharda Sirisilla, Assistant Professor on behalf of KG Shah Department of Computer Applications, welcome you all to the third day of RUSA sponsored national webinar on intellectual property rights and cyber laws. Social media platforms like Facebook, Instagram, Twitter are giving people a chance to connect with each other across distances. It has increased drastically in the pandemic. The youth is especially one of the most dominant users of social media. All this makes you wonder that something so powerful and with such a massive reach cannot be all good. Like how there are always two sides to a coin. The same goes for social media. Subsequently, different people have different opinion on this debating topic. So, in this session, we will know about regulating misuse of social media. To talk on this topic, today we have with us Ms. Kavita Munkar Nigam. Ms. Nigam is a partner in Krishna and Saurashtri Association LLP, one of the leading intellectual property law firms in India. She advises clients on intellectual property transactions, licensing, franchising, technology transfers, other commercial exploitations of IP trademark prosecution, oppositions, copyright, domain name disputes, and designs. She also deals with matters relating to infringement, passing off, conf- con- confronting, and due diligence. She has also worked on projects relating to company mergers and acquisitions, private equity, project finance, and foreign investments. She has authored articles on intellectual property rights, which has been published in several prestigious national and international publications. Ms. Nigam holds a bachelor degree in law from Government Law College, Mumbai, and bachelor's degree in commerce from Narsi Munji College of Commerce and Economics, and is registered with the Bar Council of India. She holds a diploma in cyber law from the Asian School of Cyber Laws, Pune. Ma'am also has to her credits Diplôme de Langue Francis, a degree in French offered by Alliance Francis de Bombay. She is on committees of various international intellectual property practitioners associations and is actively involved in their activities held worldwide. Thank you so much, ma'am, for accepting our invitation, and we are delighted to have you amongst us today. I request all the participants to keep your video and audio off for smooth functioning of the seminar. And if you have any questions, you can either type in the chat box or you can ask at the end of the session. Over to you, ma'am.
Thanks a lot, Sharda. This was a very detailed description and a bio of mine. Thanks for that. Thanks for the introduction. So, a very good afternoon to all of you, and I really wish we could all meet each other in person. But am I audible?
Yes, ma'am.
Yeah.
Yes, ma'am.
So I was saying that I really wish we could all meet in person, but perhaps this is what it is meant to be in the new normal. So nonetheless, we are quite lucky that we have these social platforms which keep us socially connected rather than socially distanced as is the norm these days. So incidentally, now that we're talking about social platforms, Hello.
Yes, ma'am, you are audible.
Yeah. So, since we're talking of social platforms which are helping us connect with each other and hold discussions even now, it's coincidental that I've been asked today to speak about the misuse of such platforms and misuse of social media in general, and what is the kind of regulation or how is this misuse regulated in the present times in the existing framework of laws. So let me begin with a short presentation, which can perhaps be followed by a set of questions. Sharda, if I can maybe share my screen.
Yes, ma'am. Please share your screen. Yes, now it is visible, ma'am.
Thanks. So just a minute. So I'm going to give a short presentation on the misuse of social media, and basically giving you idea on the existing legislation which regulates various social media platforms, not just the platform owners, not just the hosts of the platforms, but also the individuals who post content on such social media platforms. So I'm trying to put all of it in a nutshell so that you get an idea of how it is regulated at the moment. Also trying to explain, trying to bring in some live examples and some cases, which one or two cases, not too many. I won't really burden you with too much of case law and legal nitty-gritties, but I'll try and bring in some live examples to demonstrate, what the courts have perceived in recent times on, the misuse that or objectionable content that is uploaded on social media. So
Okay, ma'am.
I'll begin with, what do we understand by social media platforms? It's a very broadly used term and not very often defined. So we really don't find a definition as such and under any particular law at present. But recently, the Ministry of Information and Broadcasting has issued policy guidelines for empanelment of social media platforms. So this is purely for the purpose of the ministry's use of social media. But nonetheless, these guidelines have defined what a social media platform is. And this can perhaps give us some perspective on what kind of applications fall under the definition of social media. So, social media platform under the policy guidelines is defined as web-based and mobile-based internet applications that allow the creation, access, and exchange of user generated content. So this is basically what our ministry looks at when they really use the term social media platforms. So they are web based, mobile based applications, and these applications have to allow creation, access, and exchange of user generated content. Now let's see what are the examples of social media platforms, and all of these basically fall within the definition that we just discussed. So we have these platforms such as, of course, these are all well known throughout the world. So we have YouTube, we have Facebook, Instagram, WhatsApp, Twitter, TikTok, Telegram. So these are some of the platforms which are considered to be social media where users are allowed to create, generate, and share content. So while we've just discussed how social media can be so beneficial, especially now when we have absolutely no or very little physical interaction, there's another side to it, and which we've very often seen being criticized lately and being taken up in various cases in courts, and that is of posting objectionable content. So while we have the freedom to write what we want and to express our views on social media, there have been many instances of unlawful or objectionable content being uploaded on various of these platforms. So what are the different kinds of unlawful or objectionable content? So we have content which can be categorized as hate speech. We have defamatory content uploaded. There is false information. So as you, I'm sure all of you have experienced, there's a lot of false information going back and forth on, especially on WhatsApp messages and Telegram and these kind of message sharing apps. There is child abuse. There is a lot of racism, racist comments, uh, pornography, of course, uh, comments which incite violence, or some kind of religious discontent and unrest. We have terrorism. There's a lot of cyber terrorism, as they call it. There's a lot of terrorism which is propagated and promoted through various social media platforms. So these are just a few examples. There are many more. There are many more such unlawful or objectionable kinds of content which are basically put on various platforms. And this is why today we are discussing on firstly, what are the regulations at present which regulate such objectionable content? And I'll also give you a bird's eye view of what happens around the world in some of the other countries. How do they regulate, and what are the kind of laws that they have? So going to the next slide. So what is misuse basically, and why does it happen? Why do we why do we say that, as opposed to conventional media of expression or writing, why is social media being abused or misused so much in recent times? And some of the reasons are that, as we all know, it's a borderless cyberspace. There are no borders, there are no frontiers, there are no restrictions on where this information can flow. And the audience can be all around the world. So the kind of exposure that the writing has is absolutely unlimited. One of the other causes is that uh, there's a lot of potential for using these platforms for criminal activities. The reason that we just discussed is that the kind of reach it has a massive reach. And perhaps that's why one tends to use this kind of a platform to propagate various ideas. The other feature of social media is instant communication. So the moment you think of something, it can be there on the platform immediately. So you don't really need to there's no waiting time. There's no you don't have to put it in print. You don't have to wait for it to be published. So it's the publication is instant. So this is one of one of the other reasons why it's so widely used for propagation of ideas. And the one of the biggest reasons, according to me, is anonymity. So you could write anything that you want, or you could post anything that you want, in being anonymous without disclosing your identity. And that perhaps is one of the most attractive features of social media, which allows you to express yourself without being, without your face being seen, or without your face being shown to the world. So what do these platforms, all over the world, these platforms are being targeted, and they are being dragged to court for various violations. Violations more so by the users than by the platforms themselves. And where these platforms really come into the picture is that they facilitate hosting of such content, or facilitate sharing of such content. So what do these platforms do? I'll just give you a very quick, I'll run you through what these various platforms do to regulate such content. this is of course self-governance. This has nothing to do with the laws which are being implemented or which are in existence. This is purely a mechanism which is set up by the platform itself in order to monitor and scrutinize and regulate the content which is shared via the medium that they provide. So now if you take YouTube, for example, YouTube publishes a transparency report, which is updated very frequently and more so on a yearly basis, where they give you a complete report or complete statistics of the content which was in violation of law, or the content which was taken down by YouTube, the kind of people that they employ in order to monitor this content. And so all the statistics are basically given, and that's why it's called the transparency report on how they tackle the information which is shared on their platform, or the videos that are shared on their platform. So as per this report that was published recently, the latest one, about 8.8 million videos were taken down between July and September of 2019 by YouTube, by the team of YouTube. 93% of them were automatically removed by machines. So this is an interesting thing that, I think most of the platforms have learned to implement, and that's the filter, that the automatic filter that they have, and the automatic screening that they have, which has very little human intervention. So they use these kind of filters and programs in order to screen the content and remove them if they are not found in accordance with the kind of standards that are set down by YouTube. So 93% of the content was removed by machines or by programming or filters, as you would call it. 3.3 million channels were removed. So as you know, YouTube, it's possible for a lot of people to have channels on YouTube where they can keep periodically posting content. And 3.3 million of those channels have been removed in the last 1 year. Now, interestingly, YouTube employs about 10,000 people in undertaking this activity of monitoring and removing content, and also of developing a policy. So as most of us are aware, I mean, most of these platforms have their own terms and conditions and legal policies. So in order to develop these, they have dedicated a team of about 10,000 people, and also to monitor and remove content which is in violation. So this is as far as YouTube is concerned. I've given a link. I'm not sure if you would really be interested in going through the link, but I can share it with you offline, and you could perhaps just have a look at what kind of report they generate. Similarly, Facebook and Instagram. So Facebook, as you know, owns Instagram, and together they publish a transparency report. The link for that is also given here. It's similar to what YouTube does on similar lines. And here again, Facebook has disclosed that it employs more than 35,000 people around the world for implementing and regulating safety and security issues. So this is the kind of effort that Facebook and Instagram put in. Now, as per the report in the year 2019, Facebook took action on 30.3 million pieces of content. So this is a big number, and this is self-regulation, just to remind everybody. I mean, it's not something that has gone to court, but it's something that people have notified the platform. People have notified the platforms, and platforms have, on their own taken action against certain pieces of content which they found to be in violation with their policies or with the laws which are in existence. So this is what Facebook and Instagram do. So now from self-governance and self-regulation, I'll take you to the legislation, or which is something which is compulsory. Self-governance is, of course, something that they do voluntarily. It's not, they're not obliged to do it, but the kind of measures that they take, the kind of people they employ, the kind of technology they deploy, is all that they do in the kind of plans they have for regulating their platforms. That's entirely voluntary. Now we come to what laws govern the content which is posted, and what laws govern the role or responsibilities of these social media platforms. So some of the major laws that I can really list out here, of course, there will be many more which will be applicable, but these are predominantly the ones which apply to regulation of content and obligations of these platforms. So the first and foremost being Information Technology Act, which is IT Act, and there are various regulations under the Act. That's the mother legislation of all laws that apply to these platforms. Then, of course, we have the Indian Penal Code, which applies, or which gives a list of all the offenses which are punishable. We have IP laws, because since we deal with a lot of content on social media, all of this content is somewhere protected under many of the IP laws, such as copyright, trademarks, patents, designs. So these laws have various provisions on what constitutes infringement, how people can use various content which is not created by them, or if they've created it themselves, then what are the various measures that they need to take. I'm sure you've dealt with IP laws in some of the preceding sessions, so I won't touch upon too much of IP. But the purpose of mentioning it here is that the IP laws provide for what constitutes violation and what constitutes infringement, based on which action can be taken against social media the users, or the or intermediaries, or the social media platforms which are not able to remove or take down the content despite knowledge. So now let's go to the definition of intermediary. Intermediary is defined in section 21W of the IT Act 2000. So social media platforms can broadly, they are all covered under the definition of an intermediary. So intermediary with respect to any particular electronic record means any person who on behalf of another person receives, stores, or transmits that record, or provides any service with respect to that record. And this includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. So it's a very broad definition which includes most of these social media platforms. Uh, they all come under ISPs, or service providers, and hence come under the definition of an intermediary. And the reason why the definition of intermediary is important, because the IT Act imposes a lot of obligations on what is a intermediary. I mean, any entity which qualifies as an intermediary has a host of obligations which are listed out under the IT Act. And they also have some exemption if they comply with certain norms, or if they comply with a certain conduct. They are exempt from certain obligations which is cast under the IT Act. So which is why it's important to understand right at the outset what an intermediary means. And to put it very simply, and to put it in simple terms, social media, at least for the purpose of our discussion, social media platforms are intermediaries under the IT Act. So what does the IT Act do? Basically, IT Act governs the storage, the use, the sharing of electronic information or information which is circulated on the internet. And it also imposes penalties and punishments for any kind of contravention or violation of those norms which are set out under the act. I hope I'm audible and there's no problem in
Yes, ma'am. No problem.
yeah, thanks. So, so the kind of penalties that the IT Act, I'll just take you very quickly through the penalties so that you know what is punishable under the IT Act. So one of the biggest or the largest sections which deals with penalties is Section 43, and Section 43 of the IT Act penalizes any person who, without the permission of the owner or a person who is in charge of a computer system or computer network, accesses or secures access to such computer system or computer network, downloads, copies, or extracts any data, computer database, or information from such computer system, introduces or causes to be introduced any computer contaminant or virus into the computer system or computer network, damages or causes to be damaged any computer. So basically we are dealing with things like introduction of a virus or downloading of certain data which is not owned by you, or which is not permitted to be downloaded by you. Anybody who disrupts or causes disruption of any computer system or computer network through any manner, trying to disturb the working of a computer network, or which anybody who denies or causes the denial of access to any person to access any computer system or computer network. Um, so these kind of acts are punishable, and the person who contravenes this section is liable to pay damages or is liable to compensate the person who is affected by any of these acts. So this is one of the largest sections in the IT Act which deals with penalties. There is another section there which says that whatever is not really provided for, or any kind of contravention which is not specifically punished under the act, is punished here under Section 45. And in this it says that if there's any other act which is committed, which is punishable, which is in contravention of the IT Act, which is not otherwise provided, this will be that kind of an act will be punished with a compensation of not exceeding 25,000 rupees as a compensation to the person who's affected, or a penalty. I mean, you could call it a compensation or a penalty to the person who's aggrieved by the act which has been committed. So this is what this is the civil, or maybe not the imprisonment part of the punishment, but this is the fine part of the punishment which the IT Act provides for any of the contraventions made under the act. Now sorry, let me take you to the previous slide. Um, okay, now section 66A. There is this section inserted in the year 2009, which basically is very relevant in today's times, because we can see a lot of messages being circulated and flying here and there through various platforms, including messaging apps, which may be offensive, or which may kind of cause annoyance or inconvenience or some kind of hatred, or which may cause insult or injury to the person who's receiving the message. So this is introduced in the year 2009. Just a minute, I'll just give me a minute. Yeah, sorry. So, Section 66A basically tries to punish all such offenses, which all such uploading of content, which or sharing of content, which causes annoyance, inconvenience, danger, insult, criminal intimidation, hatred, ill will, etc. And it says that any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has a menacing character, or any information which he knows to be false, or has the purpose of causing annoyance, etc., like we discussed. Any email or email message which causes annoyance or inconvenience or deceives or misleads the addressee or recipient about the origin of such messages shall be punishable with imprisonment, which may extend to 3 years, and with fine. So this is the kind of penalty which was imposed, on the kind of messages which are considered objectionable, or which kind of create some kind of discontent. There's an explanation given of what electronic mail message means and what an electronic mail means. So that I can share this section with you later, so that you can perhaps read it at leisure. Now, another section which is relevant under the IT Act is the punishment for cyber terrorism. So, what have we seen so far? We've seen penalties which are given under the IT Act for unlawful downloading, spreading of virus, etc. Then we've seen 66A, which punishes sharing of content or messages which may incite some kind of violence or annoyance or hatred, etc. Now we come to the third type, which of acts which are considered cyber terrorism. So what does this section say? Let's read this out. It says, whoever with the intent to threaten the unity, integrity, security, or sovereignty of India, or to strike terror in the people or any section of the people by denying or cause the denial of access to any person authorized to access a computer resource, or attempting to penetrate or access a computer resource without authorization or exceeding authorized access, or introducing or causing to introduce any computer contaminant, and by means of such conduct causes or is likely to cause death or injuries to the persons, or damage to or destruction of property, or disrupts or knowing that it is likely to cause damage or disruption of supplies and services. So these are the kind of acts which are considered cyber terrorism. And as you all, I mean, the reason why I'm putting this section is that perhaps we are all aware that the government of India has very recently banned a whole host of apps and platforms on the grounds that they are threat to the sovereignty, unity, and to the integrity of the country. And I'm sure you're all aware of what those apps were. There were some more than 200-300 apps which were blocked by the government under this particular provision. So anybody who knowingly or intentionally penetrates or accesses a computer resource without authorization, etc., and all of this which is likely to cause injury, or which has injured the interests of the sovereignty and integrity of India or the security of the state, or which amounts to violation of public order, or which is in violation of decency or morality, or it's in defamation or incitement or to an offense, all of this commits the offense. All of this is considered to commit the offense of cyber terrorism. So here the punishment. So what happens when there is an act of cyber terrorism? Whoever commits or conspires to commit cyber terrorism shall be punishable with imprisonment, which may extend to imprisonment or life. So that's the extent to which imprisonment can be granted. It could be imprisonment for life for doing any of these acts. Now, there are other punishments also under the IT Act, which are also relevant considering the kind of content which is shared and circulated on platforms. Section 67, I'm not reading all of them out because it will be very pedantic and very theoretical. So I'm just listing it here so that all of you are aware of what kind of punishments are provided for under the IT Act. So Section 67 provides a punishment for publishing or transmitting obscene material in electronic form. 67A provides a punishment for publishing or transmitting of material containing sexually explicit acts in electronic form. 67B provides punishment for publishing or transmitting of material depicting children in sexually explicit forms. So these are some of the other punishments. Another one is, sorry. So those were some of the punishments which are contemplated under the IT Act. And all of these punishments have imprisonment and fine as a penalty to a person committing a violation of these provisions. Now, what is the duty of an intermediary under the IT Act? One of the duties is that the intermediary is supposed to preserve and retain information. And this preservation or retention of information is purely basically from the point of view of investigation, in helping investigation and in helping prosecution of individuals or entities who commit offenses under the Act or under any other law. So intermediaries shall preserve and retain such information as may be specified for the duration and in such manner and format as the central government may prescribe. Here again, if the intermediary fails to retain this information or fails to preserve the information as prescribed by the government, that intermediary or social media platform for our purposes shall be punished with an imprisonment for a term which may extend to 3 years and also be liable to a fine. Now, Section 69A of the IT Act, which is also very important, and that is the power to issue directions for blocking certain platforms. So here the power is given to the central government or officers designated by the central government to block certain platforms or to block certain content on the grounds that it is against the interest of sovereignty and integrity of India, defense, security, etc. So this is purely blocking. It doesn't have a punishment like we have seen in the other provision that we just went by, 66F, where there was a punishment for cyber terrorism, but this is purely blocking. So this is what the government does, is that if they identify certain platforms or certain content which they feel are against the sovereignty, security and integrity of the country, they are in a position to block those sites, like they have done for many of the Chinese apps. And this is done for reasons to be recorded in writing. So the government has to come up with why they have done so and what is the reason. And mainly the reasons are the grounds which are mentioned in this section. So the procedure, safeguards for the blocking, etc., is prescribed by the government. They decide how it is to be blocked, what is the procedure, what are the safeguards, etc. And any intermediary who fails to comply with this direction will again be imprisoned for a term which may extend to 7 years and liable to a fine. So basically, once the app is blocked, if it's banned, an intermediary who fails, or if he doesn't follow the instructions of the government, he's liable to be imprisoned. Like we just discussed, there were about 200 odd apps, I think many more than that, which were blocked by the ministry under this section in the interests of the security and sovereignty. So now we've seen the kind of obligations that the social media platforms have to regulate the kind of content, and what are they supposed to do in order to meet the provisions or to comply with the provisions. Some of them, of course, are to put up privacy policies, to put up terms and conditions, to make it known to the users as to what can be uploaded on the website. So if you see, all these websites or apps have their terms and conditions which you're supposed to agree to before you use them. So those terms and conditions are basically to educate the audience or to educate the users as to what kind of content is acceptable and what is not, and how the platform is meant to be used. So those are the various obligations that platforms generally have to comply with. Now, there is also a relief or a reprieve given to these platforms under the IT Act, mainly because of the fact that most of these platforms are facilitators. They are not content generators, or they are not in a position to to monitor or to regulate content in very minute terms. So since they are facilitators, they need to be given some kind of relief. And where did this stem from? Where did this requirement of relief come from? Because if you see, all of the IT Act generally only gives you what are your obligations and what are the punishments if you don't follow those rules. So where did the need for this kind of relief come from? And the need came from, if you all remember, in the year 2004, this was a very, this was a landmark case where the CEO of Bazi.com, Avnish Bajaj, was arrested for some objectionable content which was uploaded on the website. And that is when there was a lot of lobbying, and there was a lot of demand for some kind of relief for these kind of websites and platforms, purely because of the fact that they are only enablers or facilitators and not content generators themselves. So this is the history on how this particular section 679 came into the IT Act, and how did 79 affect these social media platforms or the intermediaries. So like I said, section 79 has been brought in to the act to give relief to the intermediaries and social media platforms, and to give them exemption in certain cases, not a blanket exemption, but in certain cases. So it says that an intermediary shall not be liable for any third party information, data, or communication link made available or hosted by him, and he shall not be so liable only if 2A, B, C, all these conditions are met. That is, that the function of the intermediary is limited to only providing access to a computer system. So like I said, it has to be only be a facilitator, or it has to only be a provider and not content generator or modifier. So that should be the role of the intermediary. Then they can ask for exemption under this section. The intermediary should not initiate the transmission. He should not select the receiver of the transmission, or it should not select or modify the information contained in the transmission. So for example, if you take WhatsApp on its own should not be sending any message. It should not be selecting the receiver of the message, or it should not select or modify the information which is being sent you through its platform. So in that case, WhatsApp or a platform of a similar kind can avail of exemption under this section. The third condition is that the intermediary should observe due diligence while discharging its duties under the Act, and also observe all other guidelines as the central government may prescribe. So what is this due diligence? What do they have to do in order to qualify to benefit from this exemption? So like I said, they have to put up the terms and conditions, and they have to make their users aware of what they are allowed to do and what they are not allowed to do. So these are some of the guidelines which the central government has prescribed, and the intermediary is bound to implement those in order to show or to demonstrate that they have done their duty, and anything that happens over and above that, despite the kind of guidelines they have complied with, will not be, they should not be penalized for it. So basically, they should be exempted if they are only facilitators, if they have not modified any message or they have not initiated any transmission, and if they have observed all due diligence and posted all the terms and conditions on their platforms. So these in these situations, they can avail for exemptions under the Act. Now, despite meeting all these requirements, if it has been brought to the knowledge of these platforms by the central government or any order of the court that there is some content on these platforms which is in violation or which is in contravention of various provisions of law, and the intermediary fails to take down that content despite being informed by the government or despite being pointed out by any court of law, then the intermediary is considered to be violating the provisions of the law. Then the intermediary cannot take a benefit of this section 679. That is when they are informed by the government and or the court and they fail to take down the content. I will not go through the intermediary guidelines. This is just what they are supposed to do to take benefit of section 79. Now, I'll quickly go to freedom of speech because most of this is compared with the right to speech, freedom of speech and expression, because it is very often argued that anything that you post is posted out of the, it emanates from the freedom of speech that you have under the Constitution. So yes, we have a freedom of speech. Yes, we have a freedom of expression. All citizens have that, but it's not absolute. It's not you can't have an absolute freedom of speech and expression without any restrictions. So here are the restrictions which are laid down in the Constitution of India itself, that when you say that you have a freedom of speech and expression, yes, you may have it, but it comes with a set of responsibilities, or it comes with a set of restrictions which go hand in hand with the freedom. And these are the set of restrictions. That is that you cannot express or write anything which is against the interests of the sovereignty and integrity of the country or the security of the state, or which goes against the friendly relations with other foreign states, or which goes against public order, or which goes against decency or morality, or something that is in contempt of court, or is defamatory, or is in incitement or incites violence or offenses. So these are the various restrictions which are provided in the Constitution itself. So while you say that I have my freedom of expression and my freedom of speech, that freedom is restricted by these various factors, and hence it is possible to regulate content which is posted on various platforms. Some of the offenses which are committed by people and by users of various of these social media platforms is, of course, defamation. If you see that, this is very often cited, and many people file suits and cases and criminal complaints for defamation, which has occurred on various of these social media websites. So I'll just quickly show you what defamation is, and this is defined under our Indian Penal Code. I'll just be a little fast because I realize that we have very little time left. So defamation is anything which by words either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm, or knowing to, or having reason to believe that such imputation will harm the reputation of such person. Basically, anything which in writing or in speech or in representations causes some kind of allegation, or it makes some kind of allegation against a person which is meant to harm the reputation of that person, that amounts to defamation under the Indian Penal Code. These are some explanations given under that section, which I'll not go through. The other offense, which is very commonly cited in a lot of social media posts, is deliberate and malicious acts intended to outrage religious feelings of any class by insulting the religion or religious beliefs. So these are some of the provisions which are provided under the Indian Penal Code, which are offenses, and hence can be hence a person who contravenes these or who commits these acts can be punished under the IPC. Infringement, of course, like I said, anybody who posts content which is not created by them, which is copied from somewhere else, and it's not original, or it's not novel, or it's not something which they either have a license to or they have created themselves, all of this amounts to infringement of IP laws. So this again amounts to a violation, and the kind of content which goes against these laws can be taken down, or action can be taken against that kind of information. Now, the Ministry of Electronics, Information and Technology has informed the Parliament that 3,635 social media pages and accounts were taken down in 2019 for violation of the IT Act. So we've seen all the kinds of offenses which are listed in the IT Act. Any site or any page or any account of a user which may violate any of the provisions of the IT Act can be taken down. And as per the statistics, it's 3,635 last year. Now, this is a very important case which I'm deliberately bringing in just to show you. We saw Section 66A some time back, which said that anything which you post which causes annoyance or which causes some kind of injury or insult to somebody is punishable under the IT Act. So there was this case in the year 2015 where two women in Mumbai had posted. This was followed after the this was after the death of Bal Thackeray, and after his death, after his demise, there was some unrest and there was some bandh called for in the city. Upon which two women posted some criticism on Facebook saying that they really didn't understand why there was a bandh, or why there was so much unrest. So based on those comments, those two women were arrested on the grounds of Section 66A, saying that they were causing insult or annoyance, or they were trying to incite violence. And based on that, they were arrested by the police. The women were released later, but after their release, they filed a PIL questioning this very Section 66A and asking, the court as to why this Section 66A should be, why it should be still there in the part of the IT Act, or why it should be a part of the IT Act, why it should not be struck down as being unconstitutional. So this is a case which dealt with the validity of Section 66A, which says that certain messages or content which causes annoyance or insult or injury should be punished. So the Supreme Court in this case analyzed the entire section and decided that it was not valid, or it was unconstitutional, because mainly because of the fact that causing annoyance or causing insult or injury is very subjective. You can't really there's no definition of what is annoyance or what is hatred or what is insult. So based on the vagueness or based on the ambiguity of these terms, the Supreme Court decided that this section was unconstitutional, it was not valid, and it should be struck down. So in the year 2015, the Section 66A was decided to be by the Supreme Court was decided to be struck down. 69A, of course, which deals with blocking of certain content by the central government, was held to be valid. Section 79, which offers exemption to intermediaries, was also held to be valid by the Supreme Court. And here the Supreme Court emphasized that when in Section 79, when you impose an obligation on the intermediary or the platform to take down certain content, that obligation really spins off, or that starts when the platform is informed either by the central government, by an or competent authority, or by the order of a court of such objectionable content or violating content. So this is what the Supreme Court clarified, that on their own, they are not, they're not competent. Social media platforms on their own are not competent to really decide whether a particular information or content is objectionable. And hence, they need to be informed either by the government or by a competent authority, following which they are obliged to take down that content. So these were some of the factors which were clarified by this case of Shreya Singhal. This is just to give you an overview of what kind of laws are in force around the world, which deal with social media content and regulating such content. I won't read it out because there's not much time left. So this is Germany. They have an act which came in 2018, which obliges platforms to remove anything illegal within 24 hours. And this is the kind of fine that individuals and companies can be vulnerable to. EU, of course, have rules on data protection. It's called the GDPR, which are the regulations which deal with data protection. They have a copyright directive on certain kind of content which is posted, which is infringing copyright. And of course, they have fines for the platforms which do not comply with these regulations. Australia again had an act passed in 2019 after the live streaming of New Zealand shootings on Facebook. So there were penalties for social media companies. They also have another online safety act which empowers authorities to take down abusive or harassing posts. Russia, of course, has a new law in 2019 which gives regulators the power to switch off. Regulators are the authorities to switch off connections in an emergency. So they can just take away or block connections of platforms if they feel there's a situation of emergency. So here in India, in addition to all the guidelines and the laws that we've seen, there are some amendments which are proposed to the intermediary guidelines, which are still not in force, but which have been published to invite comments. And the amendments that are sought to be made is to make the intermediary more obliged or responsible to help in tracing out originator of the messages. So if the government or the authority or the court feels that there's some kind of information or content which is flowing back and forth, which needs to be pulled down, and they want to find out who the original or originator of those messages is, they can get that information from the intermediaries if this amendment comes into force. So intermediaries are basically meant to help under the new amendments. If and when they come in force, they are meant to help the government in tracing out the originator. It also sets down timelines for providing the information to the government. So if the government approaches any of these platforms for any kind of information about unlawful content, there are some timelines laid down in the new amendments which make the intermediaries responsible to provide that information to the government within that particular prescribed time. They are also obliged. So as on today, they are not obliged to deploy any kind of technology-based tools or mechanisms. All that they do is done voluntarily. It's not enforced on them. But now under the new amendments, they might be obliged to deploy technology-based tools to proactively remove or disable content which is considered unlawful. So I'll conclude. I'm sorry, I had to really run very quickly through the last couple of slides, but I'll conclude by saying that, although the amendments or the modifications to the intermediary guidelines are still not in force, what we need to really look at is, going forward, we really need to think of whether we really need any laws, or whether we really need any enforcement agency to separately deal with violations or misuse of content or misuse of social media platforms. Or are we comfortable, or are the existing laws sufficient to deal with the kind of offenses or to deal with the kind of problems we face with the use of social media? And while doing so, while deciding on whether we really need new laws and enforcing agencies, we really need to understand that there has to be a balance which has to be struck between ease of doing business, between freedom of speech and expression. So you can't really go down so minutely regulating every form of content in a manner that restricts or restrains people's freedom of speech and expression. So a balance has to be struck between entities doing business, entities like WhatsApp, Facebook, Instagram, and all of these social media platforms doing business seamlessly and freely, and the freedom that all the users have to express themselves on these platforms. And also, the third arm of the whole discussion is to prevent certain content which can cause a lot of trouble, and which can cause a lot of which can incite a lot of violence, and which can harm a person. So a balance, a fine balance has to be struck between all of them while deciding what kind of laws we really need, or whether we really need to implement the existing laws more efficiently. So this is, I think, food for thought, and we all need to really think about it, and maybe we just wait, because we might be having some amendments coming and being published very soon. Thank you. So this is I
Yeah, ma'am. If anyone has any questions, you can type in the chat box, or you can unmute yourself and ask ma'am directly. Ma'am, I have a question.
yeah.
We spoke about defamation.
Yes.
We came to know that if an organization or somebody finds that unfair data or something is posted against them,
Right.
and what all punishments they can get, and what all laws are there. But if a person in person finds anything objectionable to that person is on social media, what that person can take the first step? Like, ma'am, we have a cyber cell in our college, so students can take help of that. But otherwise, the layman,
Right.
what they can do, very first step.
Yeah, like I said, it depends on what kind of offense is committed. So if it's defamation, they can file a criminal complaint. So they can, file a criminal complaint for defamation, or they can even sue in a civil court of law for the civil kind of wrong of defamation. So defamation can be civil and criminal both, and they can choose on which action they want to take, and accordingly sue the person who's sue the platform. And in most of these cases, since you're not some of the messages might be anonymous, and you may not really know the identity of the person who's posting it, and
Yeah.
especially in the case of celebrities, there's a large amount of trolling which goes on, and there's a large amount of anonymous comments and messages which are being sent to them. In those kind of cases where you don't know the identity of a person, most cases, the social media platform, or the medium, is also dragged into the either the suit or the complaint.
Okay, thank you so much, ma'am. I'll just check. Yes, ma'am, there is a question. As you said, the objectionable content on social media is blocked if complained by government or any authority. Does that person or group of people spreading that content are also punished?
Yes, for inciting violence, and for inciting any kind of discontent, especially religious discontent, and insult, there is a provision under the Indian Penal Code, and action can be taken against the person, of course, who's actually posting the content. Now, I won't really go into the details of the case, but I'm sure all of us are aware of the Prashant Bhushan case, which has just, kind of taken place, where the Supreme Court suo moto took cognizance of the kind of comments he put on Twitter, and that was considered contempt, and he was fined for it. Of course, the fine was, something that we all know. It was just a rupee. It was he was fined with rupee to for the kind of comments that he had posted. But this is the kind of cognizance that can be taken for any kind of objectionable or insightful comments that are posted.
Okay, ma'am.
Yeah.
Ma'am, we can take a last question.
Yes.
If the app is banned, is there any chances of bringing that app again in the market?
As long as you comply with the provisions, as long as you can demonstrate that you have kind of refurbished it, and you have made it made it compliant with the kind of requirements that are there under law, and if you can demonstrate that it's not it's no longer it's no longer violating the sovereignty or the integrity or the security of the country. I think so long as all these factors can be demonstrated, definitely, I mean, you can reintroduce or kind of get it back into the market.
Thank you so much, ma'am. I realized that we could have more time with you because you had to run also, and there is a lot of information with you which will be helpful for us. We will definitely see if we can have one more session with you.
Thanks.
On behalf of the entire organizing committee, I would like to take this opportunity to thank Ms. Kavita Nigam for sharing her immense knowledge with us on a very important topic. Ma'am, your suggestions will definitely help all our participants in regulating misuse of social media. I thank RUSA for giving this opportunity to organize and learn from such important sessions. I also thank our management members and principal ma'am for their encouragement and continuous support. I thank all the delegates for participating. Thank you all.
Thanks, Shada. Thanks. I'm glad that you found it useful, although I couldn't really
Yes, ma'am.
touch upon various things in detail. So thanks a lot. Thanks for the patient listening.
Okay. I now invite Ms. Manjot Kaur to start with the next session of the day.
Thank you, Sharda. I am truly overwhelmed by the range of discussions that we have been exposed to in the past 3 days. In these challenging times, creative and innovative inventions seem to be the solution, and indeed, all the speakers, right from Ms. Napinai, have thrown open new thinking and created a greater awareness about the relevant rights and laws. The new technologies, while they are exciting and have many positives to them, they have the flip side as well. They have enhanced the possibilities of invasion into the privacy of individuals and provided new tools in the hands of eavesdroppers. Individual privacy is at a greater stake than ever before. Computers and the internet can be used without our knowledge to amass huge amount of data regarding people, profile it in various ways, commodity it, and deal with it in a manner which could violate an individual's privacy. Online defamation has also become a serious problem due to its ramifications emerging from the widespread coverage, instantaneous communication, anonymity, and impersonation. The ease with which the defamation can be done using any of the digital devices such as mobile, computer, and laptop, coupled with the comfort of which identity can be spoofed. In fact, online defamation has become rampant to settle personal scores, harming the reputations of individuals, politicians, and companies. The impact of such imputations can be aggravated by morphing, fake videos, and voice, the manipulations that have become easy to consequent to the use of artificial intelligence and other advanced technologies, which also make the detection more difficult. This sounds ominous and worrisome. And so, keeping this in mind, our topic for today is privacy, defamation, and data protection in cyberspace. And today we have a bigger panel of speakers participating in the panel discussion. Our chairperson for the panel discussion is Mr. Subramaniam Bhuta, an extraordinary and extremely appropriate person to chair the session. He has been an advocate and former senior vice president legal of Tata Infotech Limited and Schoolnet India Limited. His particular areas of special interest are, to mention a few, information technology laws, intellectual property rights, and e-commerce laws. His name features in the IAM magazine of London in the 300 leading IPR strategists of the world. With over 40 years of experience, Mr. Bhuta has provided consulting and training services to leading companies in the development and implementation of corporate IPR frameworks, IP strategies, policies, processes, and roadmaps, e-commerce laws, information technology laws, and complex licensing transactions. Previously, he has worked for over 25 years at senior levels with leading organizations including ILNFS and joint venture of Unisys Corporation USA with the Tata Group. Mr. Bhuta is a founder member of the Technology Law Forum, member of the International Technology Law Association, and past president of Licensing Executive Society India, an affiliate of Licensing Executive Societies International. He is a former lecturer of IT laws at the University of Mumbai's Department of Law for LLM students. He is a part of various committees and has innumerable affiliations, including being a member of the Computer Law Association, the first member of LES India to attend the Train the Trainer program, advisory board member, BNA International London, former member group on TRIPS Confederation of Indian Industries, and the list goes on. So we are indeed delighted to have him today in our midst. Thank you so much, sir, for accepting our invitation and being here. To introduce the other expert panelists for today, I would like to call upon Ms. Neetu Singhi and Ms. Sudha Lawrence. Over to you, Neetu.
Yeah. Yeah, am I audible?
Yes, Neetu.
Okay. Good afternoon, everybody. And my name is Neetu Singhi. I'm working as an professor in the BCA department of Dr. BMN College. And it's my proud privilege to introduce before you two eminent personalities who are the speakers for our panel discussion today. I would like to begin with Ms. Kannan Rele. She is right now working as a group head legal, reality film production house, F&B cinema exhibition, IT and commodities. Former partner at Singh & Singh, Malhotra and Hegde, Ms. Kannan is a seasoned lawyer with over 18 years of experience in strong leadership positions. Ms. Kannan has a strong foothold in various areas of law with an emphasis in the area of technology, media, and telecommunication laws, as well as corporate laws. She has handled very sensitive and big-ticket litigations and arbitration matters. Her overall extensive and in-depth in-house expertise makes her adept at understanding the business and commercial aspects involved in every transaction, which gives her a strong competitive edge. Over the years, Ms. Kannan has advised clients on complex and high-value media and technology transactions, real estate transaction, recovery matters. She has worked with clients to execute their strategy while advising them against pitfalls across multiple jurisdictions. She has extensive expertise in corporate compliance, litigation strategy, arbitration, acquisitions, labor laws, copyright royalty related issues, media and advertising contracts, social media and data privacy matters, and complex IPR assignments. Ms. Kannan has served as a head legal and VP at renowned advertising, marketing and public relations company Ogilvy and Mather, India Reliance Media Radio 92.7 Big FM, Tata Interactive Systems and Tata Infotech Limited. So we welcome you, Ms. Kannan. Welcome on board with us for the very interesting panel discussion today. I would now like to introduce Ms. Sonal Sharma. Ms. Sonal is currently the head of legal for NBS India and NGSC Hyderabad site operations. She is advising on their shared function legal matters and is part of NBS leadership in India. Prior to Novartis, Ms. Sonal worked with Atos as General Counsel for Atos and its subsidiary companies in India, and Deputy General Counsel for APAC APAC. She was responsible for overseeing Atos legal, corporate, and commercial compliance and litigation matters of various companies. Ms. Sonal has expertise in commercial laws, HR laws, corporate laws, and managing complex forensic investigations related to compliances in India. Ms. Sonal has also spearheaded many M&A transactions within Atos in India and has been instrumental in devising IP strategy for their key clients. Her diverse areas of practice include structuring strategic business contracts, intellectual property rights, global compliance design and audits, legal due diligence, mergers and acquisitions, and arbitration, litigation management. Before joining ATOS, Ms. Sonal headed the commercial contract portfolio in Persistent Systems and was responsible for their US, Europe, and India geographies. Ms. Sonal has spearheaded the ISO 27001 process for legal department at Persistent Systems, which became the first legal department in India to be ISO certified. Ms. Sonal is contributing with her professional experience since 19 years in field of law and compliance. She holds a bachelor's degree in science from University of Mumbai and law from India's prestigious Government Law College, Mumbai. She is also a winner of the General Counsel of the Year female category by IDEX Legal Awards 2016. That's really, really great, Ms. Sonal Sharma. And I welcome Ms. Kannan Rele and Ms. Sonal Sharma for the panel discussion. And now I hand over to my colleague, Ms. Sudha Lawrence, to introduce the other two speakers. Over to you, Sudha. Thank you very much.
Thank you, ma'am. Good afternoon, everyone. I'm pleased and honored to introduce our expert panelist, Ms. Atri Mukherjee, for today's panel discussion. Ms. Atri holds a Bachelor of Arts degree in History from Lady Shri Ram College, Delhi University, and LLB degree from Mumbai University. She has over 16 years of experience in both corporate, in-house, and law firm roles. She was part of Tata Group Legal. She has also worked for PwC, a top professional services firms, and some reputed law firms. Currently, Ms. Atri heads legal at Tata Industries, which builds next generation tech-based businesses for the Tata conglomerate. She specializes in advising on investments, mergers and acquisitions, joint ventures, and technology licensing. She is also a director at Impetus Biosciences, a Tata Sciences company, and advises on its strategic transactions. She is a member of the governance committee of the Bombay Chamber of Commerce and Industry. Ma'am has even co-authored a book on workplace harassment. Ma'am, we are lucky to have you amongst us today for the panel discussion. Our next panelist for today's panel discussion is Ms. Soumya Agarwal. She is a senior legal corporate professional with over 18 years of diverse experience in mergers and acquisitions, IPRs, data privacy and compliance, and also contract management. Currently, Ms. Agarwal serves as Group General Counsel of Fractal Analytics, which is one of the most prominent players in the artificial intelligence space. Prior to this, Ms. Agarwal has held leadership positions at Ginger Hotels, a Tata enterprise, Publicis Group, a global advertising firm, a Tata PepsiCo joint venture, Narishco, Wipro, and UK Modi Group. In addition to this, ma'am is also a keen learner, an ardent practitioner, and a trainer of heartfulness meditation. It is indeed a great privilege to have you, ma'am, as a panelist. I take this opportunity to welcome you both as our panelists for today's panel discussion. Thank you.
I would request Mr. Hooter to kindly start on with the discussion and take over the session.
Thank you. Thank you for those introductions. Can you hear me?
Yes, sir.
Yeah, okay. We have a very distinguished panel, so we will not spend too much time on preliminaries. Just to set the background, however, the internet is a very, very powerful game changer. As we can already see, there's no need for me to explain how and why. You can see the impact on our life. If there's no internet, banks stop, insurance companies stop, retail stops, so many other businesses stop. If there's no internet, entertainment stops. I mean, you can do without the TV nowadays, but not without the internet. If there's no internet, social interaction almost comes to a halt because we don't visit each other anymore. We WhatsApp each other or interact on Facebook and so on. So what has the internet done? It has taken over our working lives. It has taken over our social interaction. It has taken over entertainment. So it takes over all the three most important things that human beings do, and therefore it's of great consequence to all of us. Now, there is a good side of it, obviously, and there is the other side. And the nature of law and the purpose of law is to make sure that all these three are regulated. Earlier, there was no need to regulate social interaction because it was purely personal and based on your family or your friends. You visit them. That's about all. But now it has become necessary because you do it through a business application like Facebook and so on. Therefore, the law steps in. Similarly, with entertainment. Entertainment is no longer mere fun or games. It is serious business. It's multi-billion-dollar businesses. So obviously, the law will step in. So in this panel, we have four very distinguished speakers. So let me start off with asking a few questions. May I start, if you don't mind, with Atreyi? And we are going to talk about two very major issues: data privacy and defamation. So let me start off by asking Atreyi.
I'm on camera. Yeah, what happened?
Hello.
What happened? Okay.
बस मैं एक्चुअली बराज में बात कर रहा हूँ आपका जरा हेल्प चाहिए मेरे को जरा आपका हाथी का कनेक्शन रिकनेक्ट करने का है मैंने पेंटिंग के लिए डिस्कनेक्ट किया था जरा जल्दी आके कर सकते हो ज्यादा काम नहीं है
What was that? Okay, let me continue. Atreyi, what is the significance of data privacy? Why is it become so important suddenly, or is it not so sudden? What do you think, Atreyi? And now, when Atreyi finishes, I would request the other panelists also to talk about the same topic. What are the views? Because some of the topics overlap, and it will be a good idea to get 4 different views on the same topic. But start with Atreyi.
Sure. Thank you, sir. And I'd like to thank the college for inviting me. Being an alumna of LSR, it's very great to be invited to speak at a college for women. So it's a very pertinent point that you made, that internet is all pervasive. And I think the Supreme Court has also recognized having access to internet as almost as a human right. So in this day and age, when we are, when the world around us has completely become digitized and our use of internet is so pervasive, we are constantly also sharing our personal data. From, as you rightly said, from entertainment, whether we are downloading gaming apps or we are, subscribing for streaming channels, we are constantly sharing our data to the more important and essential services, like, for example, our banking services, telemedicine now as it is. So we are constantly sharing not only personal basic identifiers, but we are also sharing sensitive personal data like our financial information, our credit card numbers. Every time we are logging onto an e-commerce website and we are shopping, we are putting out our credit card numbers, etc. out there, all of which is actually sensitive personal data. So this constant sharing of the data that we are doing is also necessitating this increasing awareness of the level of protection or the level of control that we must exercise and have over the data that we are sharing, right? So it is important for us to sort of understand that what are the guardrails around the data that we are sharing. When we are downloading apps, when we are visiting websites, we are usually not reading anything of the privacy policies or the terms of use. It's just a tick in the box, right? And we are sharing the data on these websites and on these apps with the understanding or with the implicit sort of a consolation that we know that this data is going to be handled safely, is going to be kept secure. We don't expect that our data is going to be used in a manner that is not being authorized by us, or that is being expected by us rather. But it happens, we know that, right? Now, there are certain things that, is not really in our control. For instance, if the person that has collected our data, the website, the app, the company that has collected the data, has not maintained security principles and policies, and as a result, security is lax and there is a hack and our data gets stolen. Or, for instance, there is a breach that, it's not a security issue, but knowingly and willingly, the entity has breached the law, has breached its own privacy policy and terms, and has, sold the data, for a gain. That can happen, and for that we have to take recourse to legal remedies. But there is also a part of it where we can exercise some level of diligence, and that is where it becomes important for people to be aware of their rights. I think over the last few years, the awareness of privacy and the right to your own data, and the right to the fact that it is an important right to be guarded, protected, that has increased. Especially I would say that with the Puttaswamy judgment of Supreme Court in 2017, which is also known as the Aadhaar judgment, where the right to privacy was recognized by the Supreme Court as a fundamental right read into Article 21, that's the right to life. I think that from there on, the understanding and awareness of data privacy has kind of enhanced and increased. And I think therefore it is because what is the let's look at the repercussion of our personal data getting used in an unauthorized manner. Of course, at the end of one end of the spectrum, the scariest end of the spectrum, we have things like theft of identity, where somebody poses as Atreyu Mukherjee, who's not Atreyu Mukherjee, and undertakes transactions, in my name. Suddenly, Mani sir, you receive an email from me, which obviously I have not sent. There can be loss of reputation, there can be financial loss, there can be any number of repercussions that can happen. There can be blackmail, and a lot of things. That is one end of the spectrum. At the other end, perhaps a misuse of certain posts and certain photographs or certain other information that I may have put out on social media. So just the other day, I was seeing some a news item where a lady says that she's a travel blogger, and she had put up a photograph. I think I don't recall what social media platform she had shared it with. It was either Facebook or some other platform, and she had shared a photograph of a coffee mug which she had found very interesting on one of our hotel stays. And she had put that photograph on the platform, and suddenly she saw one day in a newspaper, she opened the paper, and in some advert or the other, she saw that photograph being used. So when she went back to the platform, they said that, oh, but when you put up that photograph, you have signed off a license to us to use the photograph in whichever manner we want, and which we have done. So it again comes down to us also being apart from the duty on part of the websites, apps, all the entities that are collecting our personal data, most often to provide the service that we are seeking from that, the service and the product that we are seeking from them. At the same time, it is also our duty to be vigilant about where, why, and in what manner we are giving consent for our data to be used. So some quick tips that I could perhaps share is that when you are actually providing any kind of financial data or health data or any kind of data which you consider as sensitive, please do at least scroll through the privacy policies and terms of use of such app. Even if you're just reading the headlines, if something which is very off is likely to catch your attention, hopefully, and you would know, and you can then ask them questions about that. So that's one of the things that you could do. Secondly, just be careful about telemarketers calling up and saying your bank account details or your insurance details and all that. Your banker knows your details, your insurer knows your details. They're not going to call you and ask you about that. So it is about also a level of diligence. But I think Mani sir, that people are becoming more aware than they were in the past, and as a result, I think that a lot of fraudsters in the past who have just had a lot of fun in the past, fooling people about their financial details and all of that. I think that has significantly come down now, hopefully. So, but yes, I mean, like indiscriminate downloading of apps and websites and just, ticking, just doing a tick in the box, that ideally should be avoided. In physical interactions, when we go to malls and shopkeepers will say, madam, what is your phone number? Why? What are they going to do with the phone number? I know that, madam, hamara offer aayega to hum aapko mail karenge, but message karenge. But it's all right. I mean, if it will happen so many times that you have given your number to one shop and suddenly various other brands and shops are sending you messages. How is that happening? It's because that data is being transferred for a gain by the entity with whom you have shared the data. So just be careful about how data is being transferred and shared.
Thank you, Atri. That was good. Soumya, you have any thoughts on the same topic?
Yeah, I would like to add, maybe give an example of a celebrity, Kim Kardashian. I don't know how many of us know, but she's a very famous YouTuber, Instagrammer. In fact, with her, she posted a photo of her husband giving a diamond ring, and she was in Paris, and then she got robbed the same night. And what came to light was that she was being followed for a period of 2 years by these robbers, and they were tracking each and every detail of hers while she was posting her pictures in terms of where she is, what she is doing, and everything. So they can just completely track down what you are gonna do next, and that's really scary. If something like this can happen to a celebrity who has all the bodyguards and everything, what can happen to people like us who really don't have the luxury of going and having those bodyguards and security? So I think it's very important of what we are going to post on social media, whom we are posting. Are we actually securing our profiles? I have seen many of the people who have Facebook profiles. Are they securing their profiles enough to see, okay, their photos can only be seen by friends or their family members and not for everyone? If there is an impersonation happening, are they aware of that, what they need to do in terms of reporting to the police or making a complaint with the cybersecurity cell? So I think the responsibility lies on both the sides.
Yes.
In fact, I would like everyone to see a documentary on Netflix, that's Social Dilemma, in terms of how the data that's being shared by us is being used by these companies for their own benefit, and how it really goes ahead and modifies the customer's behavior, even to an extent of leading to social unrest, violence, and whatnot in different countries. So I think this is a very pertinent topic for everyone who is dealing with data and dealing with social media. And that's very unavoidable.
I'm glad you brought that up, Soumya, because, police also warns against, always saying that, you're not at home, you're somewhere else, you're checked in at an airport, you're checked in some hotel. Because if somebody is stalking you, exactly what happened to Kim Kardashian, the person knows that you're not at home. For instance, if they want to burgle somebody's home, right? Or where you are at, or as you said, in case of celebrities and all, if they are, if they have on themselves like, very expensive diamonds and jewelry and all, they know when to mug, when to burgle and all of that. So I'm glad you brought that up. I mean, people really need to be careful about how and in what manner they're sharing personal data on these websites.
Thank you, Soumya. I really like the example. Atri, you too. I mean, I like the examples you gave, which will actually alert people as to care they have to take in personal life. Sonal, what are your thoughts? I mean, this is particularly relevant to women, I think. You've got to be extra careful, I guess. What do you think, Sonal? And later on, Kanan can chip in on the same topic.
Sure, Mani, thank you. And first of all, let me thank the college to give me this opportunity to speak and share my views. And I really love the views of my colleagues there, Atri and Soumya. Very relevant views. And thank you, Mani, for introducing me to this panel. So first and foremost, I'll speak from the corporate aspect because that also is important. So why India woke up and realized the importance of data privacy? The most important one was the commercial angle, because when a lot of MNCs started venturing into India and set up their shops, we realized we had a very weak data protection laws. And the most powerful element in this world today is data. The one who has data, the one who has AI, they are the most powerful implementers of the world. So that is when India woke up and realized the importance of data privacy. And what we also saw is that when the usage of internet increased and the kind of cyber frauds increased, people started becoming little aware of what data privacy could be. Like not to defame any country, but today in India, it is very commonly ask, what's your date of birth? What is your name? Are you married? If you have any medical issues, okay, they will want to go in detail in history. So as far as data privacy is concerned, this is all personal data. It is not supposed to be shared. Whereas if you talk to a person from another country, they are very much aware of it. They do not want to share this information. So that is where the awareness that's seeped in and the exposure to internet made Indians realize that data privacy is important. I'm not supposed to realize it. And then we saw the sudden exploration of internet, where the moment you want to be on internet, you've been asked all sorts of this information. And then one fine day, you will receive a call from one of the telemarketing guys saying that, ma'am, you have a loan in that bank, and I'm giving you a better deal. So can you transfer your loan here? So I'm like, hey, how do you know that? This is such a personal information. This is between me and my bank. And that is when we realize that whatever is being keyed in on internet in India is not confidential. Your data is being sold off every minute. You make a transaction, you book a ticket. The moment you book a ticket, if you have noticed, suddenly you will start getting pop-ups on your computer for that particular destination, best deals, make my trip, go Ibibo, and this and that. And it just starts flooding in. Did we realize that there is an AI, it is at the back of your system, which is just monitoring you. You are being watched every 24 hours the moment you're connected to the internet machine. And that is where it became a necessity to protect the interest of individual, to protect the interest of corporate. And also there was a lobbying and pressure from NASSCOM and from various other bodies to Government of India to set up strong laws. And that is where the data protection laws of India have been drafted. They are still to be passed, but yes, it's a very robust system. So I also dealt with implementation of GDPR that was enacted in Europe, which was the data protection laws, one of the strict laws, which made India go up to that standard of GDPR. And that is when it became so much necessary for India to understand what privacy is, what data is, and how it needs to be protected. So this is a very high-level legal gyan. I'm sorry for it, but then it is important because that is where we know the utpatti, the beej of what data privacy in India means. Because we love to talk about ourselves, we love to know about what my neighbor does. Even the one who's not relevant to us, we want to know about that person. But can we ask that question? Never came in our mind, but that is data privacy. And that is what it means about data privacy. So, this is something we should start thinking, that if I don't want to talk about myself, do I have a right to know about others? And that is when this law would really be enacted in our minds and in principle. So when I talked about that you're being watched, there's a very beautiful concept about Google Watchdog, which came around 8 to 10 years back. We're talking about privacy and we're talking about strong AIs who are analyzing you. 10 years back, there was a set of people who have filed various litigations in various countries saying that you're being watched. Ever since Google was implemented and we have been extensively using Google, we can't live without Google, but the moment you put a key search on Google for anything that you search, immediately you start getting. And that is the commercial model for Google. That is how Google is earning its money and making this platform free for you. So it's not a freebie. It's not a free lunch or dinner for any one of us. So be careful. I mean, that is all I would say. I would let Kannan speak because I think we have good time and we have a lot of views to share. So Kannan, over to you now.
Yeah, thank you so much.
Thanks,
and once again, can you hear me?
Yes, we can hear you, Karan.
Okay. Yeah. So thank you, sir. I really also grateful to BMN College to invite me and really heard all from Atrey, Soumya, and Sonal. There's very little that I now need to say, but there are some examples that I have faced in, while working at organizations. So one such incident that took place recently is, one of our employees received an email stating that there is a requirement of funds. And this email she received from her boss, and her boss said, I'm in a meeting room. I need you to make payment to this vendor, and if you are okay, I'll send you beneficiary details. This employee willingly said, yes, let me know the details. Then she got beneficiary details. Our employee made payment to this particular beneficiary. One of the vendors apparently was what was mentioned. And after she made payment, within half an hour, she received another email that we need you to make 28,000 payment more. And at that time, her boss was standing opposite her cubicle, and she realized that this is a fraud that has taken place. Now, this particular incident, I feel where she has not shared any data with anyone. I think this is an issue of what Sonal said is about corporate. How these people are attacking corporates, and they have information like it is so perplexing that they knew that her boss is not around. They knew she would make payment. They targeted the individual who would willingly make payment. And it is also very disheartening when you approach a police. Police is like, we can't really assist you much because money would have been taken out from this bank account, and most of the time these banks accounts are opened by false identity, so we can't even catch the criminal. So I feel even when, yes, individuals need to be careful about data, companies also need to be very careful about implementing all kind of security related tools in place. So yeah, so this is what this was one incident that I thought was very important.
Thanks. Going back to Atri, this data privacy and personal data protection, or rather privacy and personal data protection, we, in India, we are, I read somewhere, of course, that in India, we are more worried about our physical privacy, and less about our data. We share our data more easily, but not physical privacy. But I think that is also changing a bit, because young people put up a lot of photographs on Facebook and other social media, which also is in a way physical. What are your views on this? Are we different from the rest of the world in that sense?
It's something which both Soumya and Sonal had pointed out, that it is abroad people are a little more aware about the privacy. They are more careful about privacy and data. But then again, you cannot really paint the entire, say, even the Western democracies with the same brush, because from a jurisprudence point of view, while European countries and Europe rather considers privacy and data protection as a part of human rights, but it is really dealt with in a manner of consumer protection, that it is really a consumer protection right by the United States. So as a result, actually the laws and regulations in the US are perhaps not as robust as what we have now in Europe in the form of GDPR. That's the General Data Protection Regulation. Not to say that Europe did not have a regulation before that. What they did have was a directive. Now, the difference between an EU directive and a regulation is that a directive is what it is. It's a direction to the EU member states to legislate their domestic laws around on the principles of the directive, whereas a regulation, which is what we have now there in Europe, is something which is directly applicable to the member states. Now, India's approach to, I think, the legal and regulatory approach to data protection has been quite patchy. So there are sectoral laws. So for instance, RBI has its laws, the banking regulations, which, and its directions on, data protection, which is how all our, banking, data is protected. Then IRDA has its own laws. TRAI regulates the telecom sector. So there is this, there has been this patchy development of legal and regulatory, principles around, protection of data. But we didn't quite have an omnibus, legislation to, protect data across, all kinds of activities and spheres of life where we are sharing personal data. Which is when, Sonal very aptly summarized that, how, the data protection law became, an imperative in India. And it is, I believe, in the last few years, while the first such omnibus regulation was the Data Protection Rules 2011 under the Information Technology Act 2000, which while sets out certain rudimentary principles and rights for data principle, I think it's at least a step in the right direction, and it was a first step towards having such an omnibus legislation. But naturally, with the increased digitization and the increasing awareness and importance of protecting the data, that was considered to not very adequate. And as a result, what we have now is the Personal Data Protection Bill 2019, which the first avatar was in 2018, and now we have the 2019 version, which is pending in the Parliament and being reviewed by the Joint Parliamentary Committee. This is on the lines of GDPR, because we realize, as Sonal was mentioning, that Indian companies were suddenly scrambling to apply the GDPR standards, because otherwise Indian companies would not have been allowed to process data that they were collecting from the European Union, for instance. So as a result, there has been this increased awareness where at least we know the principles that are being followed in Europe. What is the European Union standards for data protection? We are now legislating something which is on the same lines, trying to give our citizens the same rights, which are now a global standard. And I think this is also necessary because data is not borderless. Data is borderless, sorry. And the point is that, data will be transferred from, it's the way, the businesses are digitized and globalized, data would be transferred. So I think that, having a similar standard and a more uniform standard across the world would actually assist in that as well. So I think India is taking the right steps. And also, like I said, the Puruswamy judgment has thrown in sharp relief the importance of privacy as a fundamental right. So yes, I think that, we Indians are now fairly as aware, or at least moving in that direction of awareness as our foreign counterparts are, especially in European countries. So.
Thanks, Atri. That was very interesting. Any Soumya, would you like to also add to what Atri is saying?
Yeah, in fact, I will maybe try to bring a different perspective around this. See, as we see the concept of privacy as we would like to think is universal, it's not really universal. In India, privacy is perceived differently in a different context. And what information we consider as sensitive, maybe different geographies don't consider it like that. For example, earlier TB and now COVID. If someone is detected COVID, there's a lot of stigma attached to a person having COVID. Obviously, there are reasons around it. Maybe people think it spreads and all of that. And while worldwide, this is not the thing. It's just a disease which needs to be cured. So the way even the systems have evolved, or say Facebook or Instagram that has evolved, they have not developed the platform keeping the cultural sensitivity around the data privacy. So I'll maybe give an example around the Facebook policy head had to face a social wrath due to some differential treatment given to post of a political party, which led to her resignation lately. So I think this would not have happened to any other democracy in Europe. So the way we perceive data is very different in terms of privacy than what other people perceive. And someone has rightly pointed out in the panel, everyone is asking for phone numbers. Where do you live? Married, not married? I think as a community, we don't perceive that as something we should not be shared. We are okay people discussing and talking about it. So but then we have to be mindful and what we go ahead and share in the public domain, because while we think that we are sharing it only for say our friends and families, because the system is not designed in a manner to protect the cultural and social sensitivities, it can be used for cyber stalking and other issues around it. It can lead to your reputational loss or physical damage and whatnot. So I think it's a mixed thing. We would try to borrow the best of the things outside India, but then it's not something which is can be adopted in the same very manner like we have abroad, because the social system itself is very different in India.
Thanks, Sobhya. I mean, both you and Atri brought out how cultures and legal systems can cause different forms of reactions. So I'm going to go ahead and ask Sonal and Kanan also to talk about this. But before that, I want to give all of you a heads up. The next thing on data privacy or on personal data protection, we'll get all the four speakers speak is what special particular precautions should A, women take, and B, everyone says, oh, we take your consent, there is a privacy policy, you click I agree and then only we do what we do. What is the informed consent? Is it really as good as as it should be? In other words, someone has given a consent, does he or she know what consent he or she has given? It's quite complicated, I think. I think most people will find it difficult to say that they understood what they are saying yes to. So the next two questions are specifically about women and about informed consent. But on this topic of cultural issues, first Sonal and then Kanan.
Thank you, Mani. So yeah, definitely. So I'll touch upon women, but before that, just to add one more line from Soumya, because they said it right, Atri and Soumya, that yes, the data privacy, we have a little different cultural mindset, but with the onset of internet and the extensive use of internet during this COVID era has made us realize the importance of protecting ourselves because of the rise in cyber crime and, especially women. There was a very recent article almost a week back where they're saying that they have put certain AIs in place which takes women picture and it's going to be a nude picture and the women have to be careful. They have to secure their ID. Now our photos are there on Instagram, our photos are there on Facebook, except the basic security feature that Facebook has provided to us where it says that nobody can download, and this also has come after a massive feedback being given to Facebook that the pictures are downloadable. Can somebody stop somebody taking a screenshot and then filtering it and editing it and then, using AI to morph the photo as they want to? So, there are a lot of things that we have to introspect from our own security perspective. It may not be physical. I don't think after COVID, the new normal will allow us to go back to the physical era or the physical world. Everything is going to be virtual. So your crimes will also be virtual. Your data will get siphoned off. You may have a financial impact through your internet or online access, and the money is gone because it's all on virtual era. Likewise, your picture can be morphed, and it can be somewhere on digital era, and you don't know about it, but the whole world knows about it. So, you may not ever know about such thing happening, or if you're lucky, you may get to know and you can stop it with the help of a cyber police. But again, be cautious. The second important thing as a woman is that when we are putting our data on Facebook, and this is more from a corporate angle that I'm saying is, you're putting your views, you're putting your picture, you're telling where you're traveling, you're putting your travel picture, you are being profiled. And especially on a very senior leader or a sensitive kind of a assignment, if you wish to undertake, because we aspire to have a strong career as well, you're being profiled, you're being judged based on your internet post. You're being, labeled as to what kind of a person you are. So this can be common. It could be for any gender or any diversity, but be cautious. I mean, so privacy is not something the government will come and hold a stick and say, guys, think about yourself. It is something that we have to think within ourselves, that how much do we want the world to know? It is good to post family pictures. We love to see our family and friend traveling, celebrating festivals and all those things. But what if these pictures are getting downloaded and morphed and resulting in some kind of a crime? So this is something we have to think loud and be cautious. The word is be cautious. Don't stop the usage of social platform, because it would not happen. We need to be social, and this is the only way we can be social now. But we need to be very, very cautious on what we are sharing. Over to Kanan.
Yeah.
Thanks, Sonal. Over to you, Kanan.
Okay, thanks, Sonal. Yes, AI is all active every time, and we jokingly say that in advertising, if you want to crack any campaign or a brief, just talk about this product for a couple of times, and you will get similar competition ads, etc. on your screen. So AI is very, very active, and it is very unfortunate also that there are people who are lurking and trying to take data of your children, of women. They know where you are traveling, and and as Sonal rightly said, if you are aspiring to become a politician or something like that, which is a real case which happened in US, some old photographs of some mention about drug usage, etc., meant that he had to give up his candidature. So all women need to be careful about what they post on social media and what they download. So if you download all these apps where I see lots of apps about beauty apps and some other contest or quiz, etc., which also captures our data. So till we have a very robust data protection regulation in place, I think we need to be very careful about what we are downloading, what we are posting on social media.
Just one point I'll add to Kanan, and I saw this in Social Dilemma. I was not aware of it. It's a wonderful documentary, must watch for everybody. So, it showed that how AI, the beauty app that we see, which pops up and all those things, how AI is using that beauty app and helping to increase the number of plastic surgeries or cosmetic surgeries across the world. So, it spoke about that how psychologically, there is a psychological aspect, especially when you scroll down or up, and then when it drops down, how it percolates in your subconscious mind, and it is making you a social addict. So, something which was a very different concept. I was not aware to that extent, but worth knowing about that as well.
Yeah, worth watching. And just to add to what you said about psychology, so there are women who are extremely beautiful, but because when they see them a better version of themselves on these beauty apps, they are lining up to plastic surgeons and telling them that we want to look like this. So there are very, very young women who are getting misled, and also you need to be emotionally strong, I would say, for women, because there are instances where women chat on there are lots of friendship requests that keep popping up on Facebook, on and other Instagram, where unknowingly or knowingly, if you accept some profile and you start chatting with them, and women tend to get emotionally these are trained people. Women tend to get emotionally involved, and they do share their financial details or try to help them to collect some parcel. There are many such complaints that I was informed about, where the boy tries to send a parcel to India, and you are lady is supposed to pay for it to collect it from customs. So these are the kind of crimes that do take place, and especially for women, they need to be careful about making friendship, etc. on social media.
Thanks a lot, Kanan. Now, I would request each of the panelists, starting with Atri, then Soumya, and Sonal and Kanan, to talk about what especially women should be aware of and careful about in relation to data protection. And also, later on, what is this thing called consent? I mean, your consent is taken. What does it really mean? So on both these topics, can each of you talk? Start with Atreyi, then Soumya, then Sonal, and then Kanan.
Okay, so you've touched upon the nerve center of sharing of data, which is consent. There's a lot of debate that is going around now regarding the consent architecture that should be ideal, the ideal consent architecture that must be in place in order to protect our personal data. At the beginning of the session, I had spoken about, if it is my data, if I own the data, there has to be a certain level of control that I am expected to have over that data. When I share it, with whom do I share it? In what authority do I grant to the person that I've shared the data with to use the data? What is the lawful reason for which I have shared the data, for which the person, and why does the person need that particular data, for what kind of processing the person needs the data? Now, all of this falls under a privacy notice that each such entity, website, app, company needs to give to me. So the privacy notice must contain the details of what is the data that we are collecting, that they are collecting, what is the data that, what are they going to do with the data? How are they going to process the data? Are they going to do it in-house? Are they going to outsource the data to some other entity? Who's going to do it? For how long will they keep the data? And what are my rights vis-a-vis that data? Now, in the absence of a very robust and a very detailed, comprehensive legislation in the country, which is currently the situation where we deal with a very rudimentary set of rules laid down in the rules of 2011, and which mainly deal with sensitive personal data, not all kinds of personal information. It is basically this contractual understanding between the entity and the individual that governs, how the data is used. As a result, like I said, it becomes imperative for us to kind of have a knowledge of what is the privacy policy, what are the terms of use, which are all set out in the website very cleverly, right at the bottom where nobody will scroll in extremely small font and say that, you agree. And, sometimes there would be a pop-up and say that, click on the box that I have agreed, that you consent to the, none of us do it. We just scroll down and we just, tick in the box and we go ahead. So as a result, we don't know what we have agreed to. So if I suddenly see, and in that example that I gave, if that lady suddenly saw that, some photograph that she had uploaded on a platform is now appearing as part of an advert in some newspaper, she did not know that she had given consent or any sort of license to her photograph like that. So as a result, it becomes important for us to sort of have some sense of, if it is an app where you are going to be uploading your health details, for example, now that telemedicine, in the wake of COVID, telemedicine has become legal in the country. Now, as a result, you have these scores of, apps which, you can download and, access, medical assistance from a doctor. And, your medical details, that prescription that is being given to you is all there on the app. Now, when you are downloading such an app, I think it is reasonable to expect that the person would read some of the privacy policy or the terms of use of the app. But unfortunately, very few of us do so. So I think if it is something as a habit that we can inculcate, that at least, if not for all apps where we know we are providing very minimal information, but where we know that it is more sensitive information that we are providing, if we can inculcate that habit of reading at least the privacy policy, or at least the headings of the paragraphs, anything which is appearing in uppercase, those are things that we need to read and understand. Another thing is, which I would like to highlight, and this I kind of feel very this has always been an apprehension in my mind, that while adults, we can choose to take a risk. we may choose not to read the privacy policies of an Instagram or a Facebook, and we can, despite all the caution around us, whether by the authorities, whether by our friends, despite all the caution, we choose to take the risk and we go ahead and put up our photograph. Tomorrow, if that photograph is morphed or used in a way that is, unauthorized, it shows up in some, unsavory website or something. As an adult, I know what are my legal, remedies. I will approach the police, cyber cell, so on and so forth. As an adult, okay, I've taken a risk. I'm now, fallen victim to something. I will seek legal remedies. But, people put up photographs of children. And that is something that, we constantly hear, that these platforms sometimes, these very easily downloadable photographs of children are used on child pornography websites. So, and the child has not given consent to anything. The child doesn't know exactly what is going on. The child is just happy to pose for a photograph. Whether the parents or the guardians are putting up that photograph somewhere or the other, they have no idea about it. So I think that, that whenever I see some photographs of kids and all, sometimes I feel a bit apprehensive as to how those photographs would be used. So I think, especially parents, and should be careful about how they use these photographs. Women, of course, have to always be a lot more careful. I mean, it is unfortunate that women have to bear this burden of always watch your back, and always be careful about what you're uploading, how you're uploading, and so on. But one thing I would say that while we can always watch our back, but something can still go awry. We could have read the consent, form. We could have read the privacy notice. We would have read the terms of use. We would have uploaded the data knowingly, and with the belief that it's not going to. But a website can be hacked. Somebody could misuse any data or any photograph in some manner. But I think it is also important for women to be very emotionally strong, which is something that all the other panelists have also said. And just do the right thing. Go to the cyber police. Don't get blackmailed. Don't get fall into the trap of being victimized by somebody who's misusing the photograph. Just approach the cyber cell. They'll immediately block the IP of the. They will trace the IP. They will block it. We have had cases where people were being sent very obscene emails, and the courts are very quick to grant John Doe orders as well on such cases. So please resort to legal remedies. Do not get bogged down by somebody who's trying to illegally trying to treat your data in a manner that you have not authorized. So that is a message I would like to kind of give to at least all the young adults in the audience, that do not fear or do not bow down to any kind of extortion, blackmail, whatever. Do not. Just approach the police, cyber cell, approach the courts, approach a lawyer, approach any one of us.
Thanks, Atri, on women and consent. Next, Soumya on women and consent.
Yeah, I think Atri has covered most of the points. I think the problem that happens is that when they open the privacy policy or the privacy notice, it appears very legalese and no one really bothers. I think the attempt should be made to make it much more user-friendly and layman. I think we as lawyers have that responsibility of putting something for the common people and not using legal jargons. And I think that's something which is upon us, which will make it actually beneficial for users. And so it is about informed consent, and informed consent can only be given when it is something which can be understood. Because if it's legal, even if they try to read it, even if they read it, they'll not really know the nuances of it. And secondly, the fact around what legal options women have, obviously they can approach police, they can go to cybersecurity cell and all of that. But in my personal experience, what I have seen is that the police and these enforcement agencies are very slow in their response. The damage has already been done. And over a period of time, even for you to pull that social media profile, which is a fake profile or anything, it takes a lot of time. So you need really have enough proof with you in terms of screenshot, date stamps, and then fight it out. Need to be cool and just follow it up, because I think it's about change, and change will happen, but we'll have to be persistent about it. It's not going to happen in a day. So that is my side of it. I will leave for the other panel members to elaborate and discuss their point of view as well.
Sonal, on women and informed consent.
Thank you. Women is my most favorite subject. So, many things to add, and very good insight, Atre and Soumya. Few more things, as they have said, and I would reiterate, is don't be emotional if you are on social media. Don't shy away for raising any issues on social media. There's a very good policy. These content implementer like Facebook or Twitter or anybody, they have certain responsibilities under law as well. So first and foremost, stop the act and then take further steps. Take a screenshot, as Soumya said, timestamp everything, report abuse. The moment you see you have a slightest doubt over the content or the other person, every right to report it as an abuse. Do that immediately. Do not get succumbed with the thought that I may be right or I may be wrong. Always put yourself on the right side and report abuse. Very important. Because you're protecting yourself. It's a virtual era. You do not know who's there on the other side, whether it's an AI machine, even sometimes there are many profiles on Facebook where men fake as women and they do involved in chatting. And then later on, when a woman has been robbed or she's been trapped, then she realized that ID was fake and they're on the other side. So use your reasonable judgment in everything that you do. Social media is not a physical media. It's a social media. We don't know anybody over there. We cannot judge a person and know the facts and all. The second important thing is that, as Soumya rightly said, that even the privacy law, statements are not easy to interpret. Don't be in a hurry to join a platform where you realize that you're not able to understand what you're entering into it. We have this quick habit of getting the app in 1 minute. Just OTP comes and then you get steady with the app. Take some time to read the contents. If you are unable to do it, you have every right to raise question, because until we will start raising questions, things will not resolve. There is one case, I don't know much detail, it's not relevant to women on social media, but on a tobacco package, and it was granted by the court. The warnings are in very, very fine print. And this person got succumbed to cancer, and then he filed a case against this. So the tobacco company said we had warned the individual enough. The individual had still gone ahead and risked his life by consuming that. But the argument that was given was that the statements were in such a fine print that it was not readable to the consumer. And therefore, the company cannot get under the garb of it. There was a compensation granted. And eventually, therefore, now if you see on top of it, you see with red, it is injurious. Any ad that you see, even on when you go and watch a movie on the theater, the moment they show a cigarette, they say it's injurious, So these are all under public health. Similarly, even our usage of social platforms should come under the public interest, and you have every right to raise question. If you feel that you are being hampered with that right of raising a question, file a PIL, you don't spend much of it. We are there, and there are many others there. Just raise a PIL, get things done. It is just that carry the mindset of get things done. Don't be emotional. When you're dealing with a virtual world, keep your emotions aside is what my advice would be. Thank you.
Sonal, I'm glad you brought up the part of, something appearing in very small font, which is why I think when we are discussing about the privacy notice, certain things you will see appear in uppercase, like a whole paragraph would appear in uppercase, or say the heading of a paragraph appearing in either bold or something. So even if we are not reading the entire, piece, which can be quite long, and it can take some time, but at least even if we are reading the headings, we'll know if they are taking a license from us, if there is a disclaimer that they are saying that we are not responsible if there is a hack in our system, we are not responsible for this or that, which ideally the disclaimers will now appear in uppercase even if somebody is reading that, and just ask somebody if you think that you can't follow exactly what is there, because likely the court is going to say that, but when you signed off on saying yes, even if you did not read the fine print, something which is appearing in uppercase, bold, you are expected to have read that. You are a, educated person. So therefore, it is in the best interest that, even when we are scrolling, at least, read something which is appearing in uppercase. What do you think, Sonal?
Absolutely, Atri, good point. Because this uppercase concept has got derived from previous experience. We all are lawyers. We need to save our client as well. So, definitely. But again, I would say that case, because I see it my mom, like she's on her Facebook, she doesn't understand anything about law. So I tell her, you have a right to ask Facebook this question. Why are you shying away from this question? You don't need to come to me and ask her to decipher and also do that, I mean, say absolutely right point, Atre, that yes, we should be prudent, but at the same time, if we are unable to understand, feel free to ask questions.
Thank you, Sonal and Atri. Before Kanan goes on the same issue of women and special precautions for women and what is this concept called informed consent, the next sort of question is optional, but it's very interesting. I want you to visualize 3 situations. Your Internet of Things is implemented, your house, all your devices, your refrigerator, your music system, your microwave, your washing machine, all connected. They all are, programmed, and you can program them further. And, obviously they will have a lot of information about your movements and what you do and what you don't do and so on. That is one visual. The other visual is you go to a wedding or go to a conference and there's a drone taking a movie of everything, and you are with your friends or with your family, and a lot, maybe thousands of pictures of you have been taken. You don't even know that they have been taken, and you can't obviously tell the person has invited you, do you have my consent for this drone to take my pictures? So drones, and the drone will then connect to a server somewhere and upload a lot of pictures, because he can't hold that many pictures on his own. So that is the second. And third one is somewhere down the road, there are autonomous cars, and then you see, you call a Uber or Ola car or whatever is in existence at that time instead of Ola or Uber. And the car has its own memory. Car remembers many things about where you went, what you did, with whom, and so on. So is this scary? Is this good? What, there's a next round. But first over to Kanan for women and informed consent.
Yes, thank you, sir. As rightly said by Soumya, Atri, and Sonal, that we need to read whatever documents are available, policy, disclaimers, etc. But I want to cite one incident. So many years ago, when this WhatsApp was introduced, we all downloaded WhatsApp and we started chatting on WhatsApp, etc. But one of our friends, he read the policy and he refused to use WhatsApp. And and many people are making fun of him, and he was left out from communication and whatever office groups, etc. So I would tell women that, as rightly said by Sonal and Atri, you shouldn't join bandwagon. You should understand that you have rights. And you can always file PIL if you think that certain apps are violating your personal rights. Similarly, when we talk about these issues, I think government is also intervening when they understand that certain data privacy violations are taking place by apps, and they are banning those apps. So I think government also assists in case of even if you have given consent, you will be protected. So I think regulation, government do come into play when this data privacy issue is, or right to privacy is concerned. Also, one more thing, Mr. Bhuta, I wanted to talk about is that at school level we should have this awareness, like how we are talking at this college. We should have awareness at school level where children understand what their rights are and how, they are very fast. We are using 1 or 2 apps and they are using some 10 other apps. They are on various gaming apps, etc. Adding their details, where they're eating and playing those games. So we should create awareness at school level, and also I would say government should have some kind of a campaign where this information reaches everyone, even at village level, because internet is available to all, because thanks to mobile, everybody can access data, everybody can upload data. So I think awareness is the key. Even if we have given consent, I think when all speak up that this is wrong, there will be some corrective steps taken. So this is
Thanks
it,
a lot,
Mr.
Karan.
Pitawan, from my side.
Thanks a lot. You highlighted what happens to those below 18, and I think they are most active or on the internet, especially with these mobiles that they have. It's amazing, and they know more about apps and other things than we'll know. It's actually inversely proportional to age. The knowledge of the internet. The younger they are, the more they know. So thanks a lot. But would you like to, in this order, same order, just think about what technology is going to do to us, like drones and IoT and connected devices and cars that have memories. What do you foresee? Can you just share some thought? That would be nice for our audience, which is young and will definitely see the future.
Sure. So, again, from if you're asking a lawyer, it actually boils down to two things. One is the law that is governing, this transaction, the law that is applicable to these organizations, these businesses, whether it is a ride-hailing, a cab-hailing website, an aggregator of sorts, or if it is like a connected home IoT kind of a ecosystem. It is about the laws that are governing them, and second is the contractual agreement between me and the service provider. So naturally, I need to feed in what is my home address, where do I want to go. Obviously, they have, say, for example, when I'm logging into Uber will obviously have my phone number, what is my home address, where do I usually go. I will feed in my office address, so I don't have to do that every time. Uber will obviously therefore end up having a profile of me as to what is the time when I go to office, where is my home, where do I usually go over the weekends. So if around that same time, if I'm logging in, Uber will ask me, oh, do you want to go here? Do you want to go shopping today? Do you want to go? Because Uber kind of expects that is where you would want to go. So the drop down, you will see that, the suggestions as to where you would like to go. So it is about the law and the contract that we are entering into. The problem is when there is a breach. If there is a breach of applicable law, so I have read the privacy policy, I have read the terms of use, I agree with it. I know that I need to share personal data with you in order for you to give me the service. I'm fine with that. So long as the data is only used for the purpose of giving me the service. Whether you're profiling me, whether you're creating a certain data set for your, you're running some analytics on my data, you're creating a data set, that's all fine with me, right? So long as you are not making unauthorized use of my data, or you're not breaching the contract that you have entered into me, and you're also not breaching the applicable law. The problem happens when there is a breach of either law or contract. And that is when we need to be, as citizens, we need to be aware of what are the legal remedies that we have, and which is where a law such as the law that is pending in the parliament right now, the Personal Data Protection Bill 2019, which I really hope becomes an act soon, will come to our assistance, where we can clearly say that, there has been a breach, and the penalties under this law are fairly high. So, so as a result, it should serve as, if it is enforced in law and spirit, letter and spirit, I think that, it would serve as a deterrent to these companies to misuse the data. You raised an interesting scenario about, going to a wedding where there is a drone photography that is happening. Sir, when we go to weddings, we are giving a consent to the host to take our photographs. Those photographs forever and ever will appear in their wedding albums, which will be online. or otherwise, or when 100 other people will go to their houses, they will open the wedding albums, and there you would be featuring in something which you thought you're looking flattering or unflattering or whatever. But it is an implicit consent that you have from a legal point of view. You have given the consent to the host to take your photograph and thereafter showcase it for all times to come. So as a result, however, the problem really happens when, again, your photograph is used in a way that you never expected. It suddenly shows up somewhere, on some website or the other, which is, very bizarre, because that's not something you would expect. You only expect that photograph to appear in the, the wedding album, whether it is online, whether it is, on Facebook, as part of the wedding photography, something that you have given an implicit consent of, right? And but suddenly it appears in some website, suddenly your sari clad photo appears in some tabloid, wherever, if you're famous enough. It's something which is you have not given consent to. So again, it boils down to consent. And what it eventually can lead to is, when you have shared some information and or photograph or any other information, it is used in a manner which can lead to reputation loss, defamation. That is when it becomes like a much more serious problem. And that is something that is also now becoming and dovetailing into a breach of data privacy. It is something that we are seeing as an evolving jurisprudence in parts of Europe, especially in England, where instead of filing defamation suits, you see, so now we have defamation suits flying around fast and thick. Politicians defaming one another, film personalities. We have defamation suits, somebody claiming 100 crores, somebody claiming 200 crores. So both civil suits of defamation, criminal suits are flying fast and thick around. What is this all about? Somebody having some kind of an access to some information. Somebody said something somewhere, somebody tweeted something, somebody put out a Facebook post saying something, or you simply have some information which you've heard and you put it out, again, in a way that the other person thinks has caused defamation or a reputation loss to the person. That is when the whole idea becomes subject to a little more scrutiny. And where recently there was a case in England where I don't know how many of our young students are aware of the Trump dossier. So there was an investigation into the the links between President Trump and President Putin and Russia's hand in US elections. So that was investigated, and it was investigated by a man called Steele, and he had created this dossier called the Trump dossier, which was later on leaked. So there were certain individuals named in the dossier, and those people, there were certain allegations about those people having dealt with illicit cash, etc. Now, that dossier was also leaked at some point. And then these individuals, 3 individuals, actually filed not a case of defamation. Now they filed it's interesting. They filed a defamation suit in the US, but they filed a case of data privacy in the UK, in England, because they realized that they wouldn't get far with breach of data protection in the US, but they could actually get a better relief in England by way of filing a suit of data privacy. So they did that, and they actually got awarded damages. They were awarded damages by a UK court, because they said that without any substantiation, if somebody says that, oh, this person dealt in illicit cash, then that is a breach of privacy, because talking about illicit cash or any other financial dealing is sensitive personal data. So this is an interesting jurisprudence that is building up, and perhaps once we have a more comprehensive law on data protection, I'm sorry I went a little technical there, but what I'm trying to say is that we need to be aware of the legal remedies that we have available with us now, and perhaps also in the future, to tackle unauthorized use, unacceptable use of our personal data. And be careful about, be vigilant and be aware about what are the guardrails of somebody to use your data. So if Facebook takes my data, Facebook jolly well not play fast and loose with that data. If I have given my data to Uber, Uber jolly well not have shared that data in a manner I have not authorized. And if it leads to any loss to me, including a reputation loss, it can also be a suit for breach of privacy. And this company will end up paying through the nose if a penalty is imposed, because the penalties are very high. It is about 2 to 4% of global revenues, depending upon the kind of breach. So corporates have to be very, very careful and aware now. Many, corporates, even now have not, complied with, the level of the standard of, data protection that they ought to. But with this act coming into picture, and unlike GDPR, we must remember that GDPR was adopted in EU in 2016, became effective in 2018, thereby giving 2 full years, 24 months to the corporates to change their policies and procedures and security infrastructure so that they could comply with GDPR. India, I do not believe that we are going to get any kind of such sort of a grandfathering provision, and as a result, I think it is going to be effective immediately. So the companies must, I think, look into that. So I think with the new law, as well as increasing awareness, where people would try to kind of be aware of what are the for what is the reason why the data is being shared, and a knowledge of what are the legal remedies if something does go wrong, I think all of it put together should resolve the concerns that people would have about their data being misused.
Thanks, Atri. In this order now, Soumya, Sonal, Kanan on the same issue, technology challenges, and then this also will be a concluding remarks, I guess, because we are running out of time, looks like. So over to you, Soumya, then Sonal, and then Kanan.
Yeah, sir, I would like to talk about the IoT, and I think that debate happened quite 2 years back. As we know, Alexa, you say, Alexa, do this, they do that. Sing a song, it will sing a song. Tell the temperature, it will tell the weather. But do we really know it tracks every moment of yours, even when you are not giving any instruction to Alexa? And when you are linking all the IoT devices together, be your smart switches, your lights, it captures every moment of ours. It even penetrates to an extent that what's your movement within the house? It's something that fits into the system. And I think no one, when uses the kind of IoT devices we use, would have thought in their imagination that these information will be used and will be archived and will be saved in their system for future further development of their clients or their own softwares to further specialize or further fine-tune their prediction. So I work in an AI company. I work with analytics day in and day out. So what we are trying to do is we are trying to do a predictive analysis basis understanding the consumer behavior basis every minute action which a person takes where the person has not even authorized Alexa or a IoT device to take that instruction. That becomes really scary because you are actually kind of a product, because we are not paying for the product in terms of just the information that we give to them in terms of instruction. We are becoming a product ourselves. And that is kind of scary for every person because you don't know where we land up in terms of if that information is kind of leaked, it can really lead to situations where we can be in physical danger also, because anyone who has that specialization in terms of cyber knowledge will be able to track down and understand if at what point in time you are alone at your home. And I think we should be very mindful when we go ahead and start utilizing IoT and start connecting IoT devices more from a security standpoint than anything else. So that is my take on this, Mr. Bhuta.
Thanks, Soumya. Sonal and Kanan in that order, again, concluding.
Sure, thanks. So from my perspective, and thank you, Atri and Soumya, you've covered a larger aspect which would have been in my mind. I definitely see a huge rise in cybercrime with IoT devices all over, our life being regulated by IoT. The reason being that our the new act is robust, but it is not in place. The current act has penal provisions, it has both criminal and civil provisions, everything, but they are not good enough in sufficient, I'm sorry to give the statement, to take care of these level of crime. And I have handled a couple of forensic investigations with the help of the investigative agencies, and I have noted that, when there was one crime and, when we were looking for data loss or something, and when we said that the servers are in US, so obviously we knew that the jurisprudence of US applied because there's a data localization law and this and that. We were talking in those level, and when I went to the cyber police and all, they said, okay, server kidhar hai, location batao. So I said US, okay, so humko US jana padega and all. And we are saying that the computer was here, the network was here. So please start from here. And with the help of a forensic agency, we could get the culprit, but we could understand the difference in the level of awareness that it needs to manage such kind of cybercrime and cyber fraud. Our police is efficient, no question on that, but still we have to gear up a lot in terms of technology. IoT has come in place. We as a consumer are sensitive, we are smart, but the investigative agency who needs to deal with this issue is still to gear up. And that is where I see a difference. The new laws are strong, stringent, but when they get passed, they become active. So therefore, till the time that gap is there, as a consumer, I advise, be a little cautious. We love technology. We want to have the best and the latest device at home. But how far can we go in compromising our security? Our safety is most important and vital. This is something that should be in our mind before we take any step towards accepting any privacy statements or start in building in any new device. So that's just a quick concluding remark from my side. Thank you.
Thanks, Sonal. Kanan? Kanan, your view?
Yes, sir. So my views are similar. However, what I want to say is that, yes, as Sonal rightly said, we must have some kind of development at our police level, at our judiciary level, to at least address and understand these concerns and give timely remedies to our citizens who are sharing data with entities who are sitting in countries where there are no restrictions also. Further, I feel that yes, technology is enabling great things. We are having greater control, much more development in our lives. However, slowly I feel it can impact decision making of people. It can impact our views. For example, even governments can be can be changed due to social media and data. So future is so in future it is scary, and unless we create awareness, we have laws implemented and remedies available, it will be difficult. It will be difficult to stop any kind of data violations.
Thank you, Karan. I think we are a little over our deadline of 2:30. So we have two questions that I can see, unless I missed something. So one question is, 1 second. Oh my God, 1 minute. Yes, I'm back. I logged out. Okay. So one question is, if we post something on, say, Facebook and someone forwards it to someone, is that a breach? Who would like to answer that one? You post some pictures and someone forwards it. Atreyi, would you like to answer that one?
So you've already given consent to Facebook to do that. That's how the whole social, I mean, that's how the product works. I mean, if you look at it as a product or a service, that's how it works. It's pretty much like WhatsApp forwards, right? You've given it, you've sent a message to somebody, and then that person has forwarded it. That's how we get all the jokes. That's not breach unless somebody is using that content in a way that is not authorized. So you posted a picture and somebody downloads that photograph, and like we said, that then uses it on some other website, morphs it, and misuses it. Or perhaps not even like morphs it, and we are going into a more prurient side of it. But for instance, somebody downloads a photograph and maybe makes a caricature out of it and posts it back on Facebook, and you claim defamation, or it is something that you consider as derogatory. So anything which is something, an activity of that sort, which is obviously not something that you've authorized or something that you have not consented to, is a breach. Other than that, that's how the product works, and you have already given consent to Facebook to and allowed people. You also have these privacy settings on your on your accounts, and these privacy settings have evolved over a period of time. So now you can prevent access of people who are not your friends, so they will not be able to access your photographs and things like that. So if you have allowed friends to access your photograph and then they forward it, so that's allowed. That's not a breach.
Thanks a lot, Atri. Yeah, I mean, we give a consent to so many broad things. And I mean, not everyone who reads this is a lawyer, like all of you, or each of you rather. So it's very tough. It's not going to be easy. There are a couple of more questions. One is that some people give a cashback offer, and then, they also take your consent to certain things. And then, could that lead to some issues of breach of data privacy? Do they need their consent before sharing that post? I guess the answer is the same. It depends on what sort of consent you are given. If you are given the consent against a cashback offer, that's it. There would be no breach, because they are actually following what they said they would do, and it's we who are not understood what they have said they would do or not do. But here's a question from the principal herself, and she says, if digital marketing is used to keep track of, or rather to track or to convert, say, prospective students, what happens then? What sort of privacy precautions will be needed?
I'll attempt this, if all permit.
Yeah, let me finish the question. Let me read it exactly. If digital marketing is used to gather numbers and details of prospective students, then is that a breach of privacy? Yes, Sonal, you wanted to answer that?
Yeah, because this is a question we answer every day in our office when our HR wants to use the data. So this is something that I jumped upon. Yes, it's a breach of privacy because you're trying to get the details of the student who may have not given consent. So you're using some third-party anonymous platform to derive the data, and it may have its number. Anything that identifies a person, it could be number, it could be the name or whatever. So if the digital marketing medium which is used or a platform which is used has a consent from the student, it's a published media, and it has a consent like Facebook or any intermediaries, then it may not be a breach of privacy. But if it is being targeted to identify those prospective students, then it could be a breach of privacy. So depending on what intermediaries you have involved for such gathering of data. I think I see Atre has some views about it. Yeah.
Sure. If anyone else has a view, they are welcome to say it now. Or else we'll, I think we are well over time. It's 14:42. Atre, are you itchy to say something, or you're okay?
No, not really. I was just complimenting Sonal on how well she has articulated the
actually,
issue.
I must compliment all of you.
We are coming back to the issue of consent, which we have done a number of times. And therefore, the importance of informed consent, which Mani sir, you have said so many times during the presentation, I think that is something that people need to understand.
Thanks. I think this has been a terrific discussion. It's not easy to to coordinate, but the way you did it Atri, Soumya, Sonal, and Kanan. I must compliment you for being such accomplished lawyers, doing very responsible jobs, and keeping track of things that are happening, not only in technology but also in law. So you'll be great technology lawyers, all of you. And so with this wonderful session, we will come to an end now. And over to you, Professor. Is it Professor Manjot Kaur will take charge? Thank you.
Yes, sir. Yes, sir.
Manjot?
Yes, ma'am.
Before you give the official vote of thanks, I just would like to thank Mr. Vetu and all the panelists for this excellent session. It's a very unique opportunity, I think, that you've given to our students especially, to listen to people who are experts in the field, and all of you have conveyed your ideas in such a lucid manner that being lay people, we still have understood. And I think that we are all going to be extremely cautious from today. So thank you, and especially to Mr. Vetu, because all this would not have been possible without your support and help. So thank you so much, sir.
You're welcome, Principal.
Thank you, ma'am. I express my heartfelt gratitude to our chairperson, Mr. Subramaniam Bhutta, and the expert panel of the top women lawyers in the country in the field of intellectual property and cyber laws, Ms. Atreyi Mukherjee, Ms. Soumya Agarwal, Ms. Kanan Rele, and Ms. Sonal Sharma for such an insightful and enriching session. Thank you so much for widening our horizon of knowledge. I'm sure it has been gainful and rewarding for everyone present here. Your messages was both powerful and inspirational to all of us. Without any further delay, I now invite Mr. Shahjahan Khan, Program Coordinator, BCA Department, to propose the vote of thanks for the webinar.
Thanks to Manjot ma'am. I'm audible, Manjot ma'am?
Yes, sir.
Yeah. A warm good afternoon to our most valued, eminent speaker, respected management member of Seva Mandal Education Society, Principal Professor Mala Panduram, all the participant, colleagues, and my dear students. As we come to end of the RUSA-sponsored 3-day national webinar on intellectual property right and cyber law, on behalf of Srimati K.G. Shah, Department of Computer Application, under Dr. BMN College of Home Science, I, Mr. Shahjahan Khan, deem it a great honor to propose the vote of thanks to all who have helped us in making the webinar such a resounding success. The 3 days of discussion about intellectual property rights and cyber laws, all sessions were undoubtedly excellent, and would like to take this opportunity to express my gratitude to all those without whom this webinar would not have been possible. We have received an overwhelming response with participations, registration from 12 countries across the globe and 22 Indian states. When we are conceptualizing this event, we wanted it to be not just meaningful, but an eye-opener to create awareness about the intellectual property rights, cyber laws, issues and challenges of cyber crimes among the students, academicians, professionals, and others. I extend my profound gratitude to our keynote speaker, Ms. N.S. Napinai, for giving the perfect start to the webinar with a very interesting and thoughtful provoking address. Our special thanks are due to Ms. Nisha Nandakumar, who helped us get in touch with the best brain in the field of IPR and cyber laws. Thanks to Ms. Srividya Gopal and Professor Suman Kalani, who gave us an in-depth knowledge about copyright, trademarks, and patents in various fields. Thanks to Ms. Kavita Nigam for guiding us on how to control and manage the misuse of social media. Thank you all the panelists who were part of today's enlightening sessions. I must our deep sense of appreciation to Mr. Subramaniam Bhutta, who have been instrumental in introducing us to a gold mine of the absolute best and most esteemed women experts who have won accolades in the field of intellectual property and cyber laws, who not only enlightened us, but have become a role model for many young women to think out of the box. Thank you, sir. I wish to thank all our management members of Seva Mandal Education Society. You have stood behind us like a pillar of strength and supported all our efforts. I wish to thank our principal, Professor Mala Pandurang. We have patiently guided and motivated the entire staff and students who have always been a source of encouragement and moral support for all of us. Thanks to RUSA for supporting us in conducting a 3-day national webinar. You all would agree with me that an event like this cannot happen overnight. The wheels started rolling a week ago as it required planning and a bird eyes for detail. We have been fortunate enough to be backed by a team of very motivated and dedicated colleagues who know their job and are result oriented. Thanks to all my staff, you all deserve a huge thank you. Special thanks to Ms. Manjot Kaurseni as an in charge of this webinar, who worked with a strong commitment for the last couple of months and coordinated to make this webinar a grand success. Excellent work, Manjot ma'am. Special thanks to Mr. Nitin Pawar for his technical support. His presence gave us confidence and helped us to relax. Last but not least, we are grateful to all our participants for your presence at the webinar and contributing to our success. Thanks a lot. Thanks to all. Over to you, Manju ma'am.
Thank you so much, sir, for the vote of thanks. So with this, we come to the end of the 3-day webinar. Thank you once again for everyone joining us for this webinar on all the 3 days. Participants are requested to kindly fill in the feedback form, and all the participants who attended the sessions in all the 3 days will be getting the certificate. Thank you once again.